Well, good morning, everyone in our Canopy Forum world. I am delighted to invite you to this very important webinar that we're sponsoring today on the question of the Johnson Amendment and whether religious organizations should make political endorsements. I am Christy Green. I'm the executive editor of Canopy Forum, and I want to give you a little bit of background about how we got to this issue and then introduce our wonderful set of panelists today. As some of you may have noticed, midsummer, around July 7th, there started to be news articles. A news article in the New York Times reported that the IRS, in a filing in a legal case, had taken measures that seemed to suggest that it was going to give religious organizations, houses of worship, more latitude in endorsing political candidates. That was followed by another New York Times article, which came up in August, which described this as sort of the culmination of an effort, particularly on the Christian right, to have freedom of speech was the justification for religious organizations to make political endorsements. That New York Times article mentioned one of our panelists, quoted Benjamin Leff, and also quoted folks from the Americans United for the Separation of Church and State. It was a very deep article, a long article, heartily recommend it. And it does contain links to the key case in this area that is going through the courts in which some of our panelists are involved in, a case filed by the National Religious Broadcasters Association in Texas, which is in the Fifth Circuit, which is known to make very interesting ruling. So we're all waiting to see how that will go. Um, there were other sort of issues other articles that we became aware of. There was an interesting article that again quotes another one of our guests today on red churches and blue churches out of the John Danforth Center at Washington University. So we were very interested in bringing this issue to our Canopy Forum public as sort of a consummate law and religion issue. And we do have a wonderful set of panelists today, including Benjamin Leff, who is a professor at the Washington College School of Law and American University. He is a nonprofit tax law specialist and has some very important insights into the nonprofit law sector and those dimensions of this case. We have Professor Michael Broyd of Emory Law School, who is the director of our SJD program, the Berman Projects director at the Center for the Study of Law and Religion at Emory University. And his area of interest are law and religion, Jewish law and ethics, and comparative religious law. So he brings the perspective both of a professor of law and an active rabbi. Rebecca Markert is Vice President and Legal Director at Americans United for Separation of Church and State, leading teams of attorneys to protect the constitutional principle of separation of church and state. And she is involved in many courses in this area, including the one that is currently making its way through the court on the Johnson Amendment. Fourth, we have Kevin Hancock, who is the Director of Campaign Finance Litigation at the Campaign Legal Center, which does a lot of excellent voting rights and election law work. He worked for nearly a decade as an attorney at the Federal Election Commission and brings important campaign finance and the possibility of dark money as a perspective to this discussion. Finally, we're delighted to have found Mark Valeri, who is the Reverend Priscilla Wood Neves Distinguished Professor of Religion and Politics, and currently serves as the director of the John C. Danforth Center on Religion and Politics at Washington University. And he will bring us a sort of historical perspective, particularly from the Protestant churches and their understanding of the relationship between church and state and whether religious leaders should be making these sorts of endorsements. I should also mention that one of the features of this debate is that it's not an entirely new debate. It came up during the first Trump administration in 2017, was kind of a flash in the pan. It was discussed, it went nowhere. But in the second Trump administration, it is back in this sort of robust form, but through the particular vehicle of an IRS filing in a legal case, which is interesting. And I will just say that personally, as an Episcopalian, I'm old enough to remember, as they say, back in 2004, when an Episcopal church in San Diego came under fire for having anti-war sermons. This was just as we were getting into the height of the Afghanistan and Iraq wars. And I was actually teaching up at Harvard Divinity School, attending an Episcopal church, and one of my students was the seminarian who wanted to start a religion and politics discussion group in the church, which actually had the assistant rector sit in to make sure that we didn't venture inappropriately into partisan conversation. So it was definitely a very live issue in my church. Which, and I can say the church I'm attending now, like many, has political divisions within it. There was recently a talk given at Emory by Tim Alberta, who has published a number of books in this area recently, and he refers to having grown up as a preacher's kid. And his latest book starts off with the story of a young minister and his father's old congregation, and having to deal with political division in the church and the real difficult position that this can create not only in the engagement of churches in politics, but in relations within the churches. So, a rich set of issues to discuss today. We're delighted to welcome you to our audience and remind you that we will have, after each presenter speaks for about 8 to 10 minutes, we'll have a period of about 15 minutes of interchange among our presenters, and then we'll have at least 15 minutes for your questions. So, if you do have a question that is emerging for you, please type it in the question and answer box at the bottom of your Zoom screen, and we will endeavor to get to as many questions as we can. So without further ado, let's start our conversation with Professor Benjamin Leff. Benjamin.
Thank you so much for that introduction, and thank you so much for including me today. So, like you said, I'm a law professor. I teach tax law at American University's Law School, and I've been writing about the Johnson Amendment for 17 years, which is 1 year longer than I've been a professor. So I've been thinking about it a lot, and I think that I'm the tax lawyer on this panel. So I take very seriously that as the tax lawyer, I think that I kind of am going to take up three tasks. The first is to just give an extremely quick primer on the deductibility of charitable contributions and the non-deductibility of expenditures for campaign issues or for political contributions. Then I'm going to talk a little bit about the Supreme Court's jurisprudence in this area. And then I'm going to very briefly talk about what the IRS did very recently and how dramatic a change it is from the position that they've been taking for decades. So first, for anyone who doesn't know, and let me just apologize. I'm going to kind of read from a script because otherwise I'll never stick to under 8 minutes. So for anyone who doesn't know, contributors to 501c3 organizations can deduct their contributions, the value of their contributions, as long as they itemize their deductions on their tax return. And just for reference, only 10% of taxpayers itemize, so the deduction for charitable contributions is really only valuable for the top 10% earners, and it dramatically magnifies the richer you are. So it really is it's what we call an upside down subsidy. It's a very dramatic subsidy for very wealthy people. It's totally irrelevant for 90% of us. Campaign expenditures, as I said, are not deductible. And the Supreme Court has described the deductibility of charitable contributions as a subsidy from the government for charitable activities. And the government's choice to not subsidize campaign contributions is often called non-subvention. That is, not subsidizing, and I'm just going to use that shorthand, the government's policy of not subsidizing campaign expenditures, but subsidizing charitable contributions. So why is campaign speech by charities, or the prohibition of campaign speech by charities, why is that a legal problem from a constitutional perspective? So quick introduction to this area of law from a constitutional perspective. The First Amendment clearly protects the right of any person to communicate ideas, including political ideas, and qualifications of candidates for office. And some believe that this communication about the qualifications of candidates for office is really in some ways the most important protection contained in the First Amendment. It's what allows us to kind of speak truth to power. This protection includes organizations, not just individuals. And so charities, including churches, have a core First Amendment right to communicate ideas about the qualifications of candidates for office. But the Johnson Amendment purports to say that they can't. So how do you square that circle? And the way that you square that circle is this. First, the Supreme Court has not said that the way that you square that circle is that the benefit of charitable contribution deduction is kind of an option, and any organization can take it if they want or leave it. But if they take it, they have to forego their First Amendment rights to engage in speech, including campaign speech. They haven't said that it's just a quid pro quo and therefore it's totally permissible. The government can offer benefits to organizations and only give those benefits contingent on those organizations giving up their First Amendment rights. Instead, they've said something slightly different from that. And the different thing they've said about that is sometimes called the unconstitutional conditions doctrine. But in this context, the leading case is a really old case, a 1983 case called Regan versus Taxation with Representation of Washington, in which the Supreme Court said the government can limit the use of the subsidy that's contained in the charitable contribution deduction and tax exemption, and deny that tax benefit for the activity of campaign speech. In other words, they can choose non-subvention. They can choose to not permit their subsidy to be used for campaign speech. But they can't use it as a carrot to get an organization to give up its right to engage in speech. And what that means is the legal scheme, the government must provide some mechanism for an organization to engage in its core free speech rights, including political speech, some mechanism that allows it to avoid using subvention. And in that case, the mechanism that is discussed is what is often called the alternate means doctrine, is the 501, the organization would use a 501c3 for its charitable activities, and it would create an affiliate organization like a 501c4 or some other organization that does not get tax-deductible contributions, and it would use that organization to engage in its campaign speech. The C3 could then devote itself to its charitable activities. And this is a very common structure. You may be familiar with massive organizations like the NRA, which engage in an unbelievable amount of campaign and lobbying activities in their C4, and also engage in charitable activities in their C3. Those charitable activities are educating the public about safe gun use or something like that. Or if you prefer an example from the left, Planned Parenthood, similar structure. A lot of lobbying and campaign activities in a 501c4 organization, and a lot of charitable activities providing healthcare directly to people who need it in their C3 structure. But it's always been challenging to think about how this affiliate organization structure, this mechanism, applies to churches. And partially that's because the kind of communications that churches engage in from the pulpit, what is usually called pulpit speech, is so at the heart of what churches do or what churches perceive themselves to be doing. So if you say to churches like, fine, you can't engage in any political speech from the pulpit, but go ahead and create a 501c4 organization, and then the 501c4 organization can engage in as much political speech as they want. The churches believe, or it's not the churches, I should be clear, it's a very small minority of churches who are upset about this, but the churches who are upset about this believe that the First Amendment should protect not just their speech generally, but specifically their pulpit speech. And that question, that narrow question, is the affiliate organization solution sufficient to vindicate churches' rights to speech, or do churches need some right to engage in pulpit speech to endorse candidates, for example? That is a potentially very hotly contested legal question, and you could spend a lot of time trying to predict what would happen if that question got to the Supreme Court, for example, or a court who has the jurisdiction to decide it. But the IRS solved this problem for many years by saying very clearly that pulpit speech violates the Johnson Amendment. Churches do not have a right to use their pulpits to endorse candidates, but they conveniently did not enforce this against churches who were openly violating the law. And lots of people speculate that the IRS was consciously not enforcing it because they didn't want to be in court arguing this narrow legal question that I just described. They were too afraid that they were going to lose it. So they avoided enforcing while stating very clearly that pulpit speech was illegal effectively or violated the Johnson Amendment. Um, and that kind of carried along merrily until last summer when, with a change of administration, the IRS agreed to a consent judgment, which my co-panelists, I think, will talk much, much more about. Consent judgment has not been adopted by the court. We're waiting for the court to have a hearing and then decide what to do. But the IRS, through the Department of Justice, agreed to a limitation that would really clearly permit churches' speech from the pulpit on core campaign-related speech, so including endorsements of candidates. And the limitation on the limitation on this exception to the rule I'm sorry, I'm way over, is that those communications must be internal to a house of worship, between a house of worship and its congregation, in connection with religious services. And so I'll just very briefly just say, so what's wrong with that exception? If the IRS wants to agree to create an exception to permit this kind of speech under these circumstances, what's wrong with it? So very briefly, there's two elements of what's wrong with it. One is that it's limited only to churches, and immediately there will be a legal challenge. To the degree to which the IRS lets it get to court, there will be a legal challenge of non-churches arguing that their speech rights are also equally violated by the Johnson Amendment. And if churches are allowed to communicate with their members, then so should everybody else. That will happen immediately, and they'll have pretty good speech arguments and pretty good Establishment Clause arguments. And then more in my line of work, tax law, also what will happen is immediately organizations will seek to expand the scope of that. So they'll try to push the boundaries of what counts as an internal communication. And we already have churches spending literally millions of dollars communicating their religious messages to a very, very wide public. It's not clear what is internal, and surely following this ruling, the very first thing that will happen is there will be churches willing to accept millions of dollars of contributions from wealthy donors who want to take a tax-deductible contribution in order to engage in political speech, and they will use that money to promote their religious message, which also will include, obviously, the endorsement or the political component. So with that, I'll stop. Thanks.
Thank you very much, Professor Leff. We couldn't have started with anyone but a tax lawyer. Blessed be the tax lawyers. Now we will move on to Professor Michael Broyd for a Jewish perspective and law and religion perspective on this problem.
I'm here not really as a law professor. I am a law professor. I work in the law and religion field. But here I'm going to talk to you as a former synagogue rabbi and a person who goes from synagogue to synagogue frequently speaking. And yet, I've taken a very clear public stand, both in a large Jewish newspaper and in countless pulpit presentations, against synagogues engaging in the endorsement business and discouraging rabbis from stepping up to the pulpit with a political endorsement of a candidate. What I think happens when religious institutions categorically endorse people is a very complicated conversation, because candidates, as opposed to causes, are complicated individuals with many stands on many different issues. And when you endorse a candidate, I say to I say to congregants throughout the United States, you end up endorsing more than a particular stand on a particular issue. When you stand up and say, on this issue, this is how our community feels, that's not an endorsement of a candidate. That's an endorsement of a cause. And if we lived in a referendum state like California, where you're occasionally allowed to go to the ballot and vote on an idea, we would have very clear views on an idea. But when you endorse candidates, candidates are inevitably complicated people. You sometimes have candidates who very strongly support your view on one issue and oppose your view on other issues. Or you have candidates who completely support your views on a number of issues, but are living lives that are contrary to the Jewish tradition. And when you endorse them, you say to your community, this is a suitable role model for us. And this creates so many complexities that it's almost never worth doing. Let's take a hypothetical mayoral candidate who's virulently anti-Israel, but in favor of helping the poor people live well in the city that they're living in. So the Jewish tradition very much looks to the support of the state of Israel as a test, but it doesn't deny that taking care of the poor among us is an also important task. And when you ask me to choose, I personally am happy to choose. Reach out to me by email, and I'll tell you who you should have voted for on that hypothetical candidate. But that public endorsement is much more complicated because it involves prioritization of values, because it's exceptionally rare that you have a candidate who supports you in every value and in every way. And any candidate who says to me, whatever Rabbi Broid is in favor of, I will vote for him, whatever he is against, I'm against, you should vote against that person too, because we don't want candidates so closely connected to a specific religious faith, as John F. Kennedy reminded us in his famous speech about Catholicism. So in no way, shape, or form would I endorse a candidate who says to me, every single bill that comes in front of me, before I decide how to vote, I will ask you, Rabbi Broid, what I should do, and I will be your faithful servant. That's not what we want either. So the Jewish tradition could imagine in an Athenian democracy where issues are put in front of voters, not candidates, but issues, that a synagogue or a church would stand up and vigorously endorse issues. California sometimes does this, and so do other states. But most states have no referendum voting. And instead, you're stuck with frail human beings who sometimes have views that support you on one matter and oppose you on another matter, or generally support you on most matters, but don't live a lifestyle that you would want for members of your community. And the act of political endorsement is thus something that almost never should be done from the pulpit. That is my view of the Jewish tradition. I am not here speaking to you as Professor Leff is, as a lawyer who works in church state. I'm here speaking to you as a person who speaks in different synagogues in many different ways and in many different settings. And when I want to talk about contemporary politics from the synagogue pulpit, and occasionally, like all of the rest of us, I get the itch. Can I tell you what I do? When I step into a synagogue, I wear a ritual shawl that I put on over me when I pray. And when I give a Jewish sermon, I keep the shawl on. And when I want to talk to my congregation or your congregation about contemporary politics, I do so after we eat. The Jewish community has a custom of after services, there's Kiddush. Kiddush is food that we all eat. Some people come just for the food, which is not so terrible. And when I want to catch them, I will speak after the food, because everybody's there for the food. And then I take my talit, my ritual shawl, off. And sometimes I even take my kippah off. I walk around with my kippah all the time, but sometimes I will take it off for events like this, stand very still because I don't walk without it on me, and talk about contemporary politics. And then I say to my congregants, or the congregation that's invited me to speak, that this is not Rabbi Broid talking to you. This is just Michael Broid. I'm the same smart guy. I'm just not functioning as a rabbi when I tell you who to vote for. That's been my practice for a long time. I've been a rabbi for almost 40 years at this point. And if I'm going to talk to you about who to vote for, and I do sometimes, it's an itch that sometimes has to be scratched. I do so not as Rabbi Broid, not surrounded by my religious accoutrements. I'm not wearing my talit, my ritual shawl, and functioning just as a guy. Sometimes when they ask me, well, if you're just a guy, what are you doing up there? And I smile nicely and say, well, I'm smarter than most of you. But that doesn't always go well, as I'm sure you can imagine. It's nice to talk to all of you, and I welcome feedback. I value electronic contributions more than anything else. At the end of one of these lectures, somebody came to me and said, Rabbi Broid, you're so much less impressive in person than you are in writing. And my wife was standing there and she was insulted, but I understood it to be true. I'm so much less impressive in person than I am by email. So if you want to get the best of me, send me an email asking questions. Thank you all for listening.
We're always impressed with Professor Boyd at Emory. But now, for a different perspective, we move to Rebecca Markert from Americans United.
I feel that this is a difficult spot to be in after that wonderful uh, remarks and Professor Leff. So good morning to everyone. Thanks so much for including me. I am not an academic or a law professor. I am a practitioner, so I'm going to be speaking from that perspective. I work for Americans United, which is a nonprofit organization dedicated to preserving the constitutional principle of religious freedom, and in particular, the separation of church and state. So today I'm going to talk about why the Johnson Amendment is important for church-state separation, give some examples of violations that have come across my desk in my nearly 17 years of working in this space. Before working at Americans United, I was the legal director at the Freedom from Religion Foundation, and worked on these issues there as well. I also before law school worked for Senator Feingold, so I've also had a lot of experience in the campaign finance world as well. But I'm going to talk about why the Johnson Amendment is important for church-state separation, give some examples of violations of the Johnson Amendment that I've seen come across my desk in my tenure at FFRF and AU, and then talk about the legal challenges that AU has been involved with, including the National Religious Broadcasters case that we mentioned at the top of this webinar. So first, the Johnson Amendment is an important tool to protect religious freedom and the separation of church and state. It plays an important role in securing religious freedom for all, in preserving the constitutional principle of separation between church and state, and in protecting our secular democracy. Religious freedom is best preserved by keeping religion apart from the corrupting influences of politics. The founders believed that both religion and government would be stronger if they operated independently. As James Madison wrote, religion and government, quote, both exist in greater purity the less they are mixed together. And a weakened or repealed Johnson Amendment blurs the constitutional line between government and religion and could even give rise to favoritism towards certain faiths or denominations. By maintaining this clear boundary, the Johnson Amendment prevents this kind of entanglement and helps ensure that the government does not privilege or penalize any religion. The Johnson Amendment also protects the financial independence of nonprofit organizations by ensuring that they're not corrupted by political campaign donations. And it allows these organizations, as has been said earlier today, including churches, to focus on their intended missions and to continue their charitable work for the public good. If some of these nonprofits start getting involved in partisan politics, it's going to erode public trust in these institutions. So, in essence, the Johnson Amendment aims to maintain a clear separation between charitable work and political campaigning. The Johnson Amendment only limits endorsements or opposition to candidates seeking public office. Churches and faith leaders already have the freedoms to speak about any political, social, or moral issue. And an example that I like to bring up is that the Johnson Amendment did not stop and was not intended to stop Dr. Martin Luther King Jr. from preaching about civil rights from the pulpit. And it likewise doesn't limit the Catholic Church from speaking out against abortion rights. Faith leaders, as the rabbi just said, enjoy the right to endorse candidates in their own personal capacity. They can even run for political office. They just can't do it from the pulpit. Tax exemption is a privilege, it's not a right. All organizations, whether religious or secular, are free to endorse political candidates, but if they wish to enjoy the benefits of tax exemption, then they must comply with the restrictions of the Johnson Amendment. This is an even-handed approach that neither favors nor disfavors any nonprofit organization, including houses of worship. So I started my legal career in 2008. My first job out of law school was at the Freedom from Religion Foundation, and I started there in October of 2008, so right before the presidential election in November of 2008. So my first real work experience in this practice area was dealing with complaints about pastors endorsing or opposing candidates. And I want to give you a couple of examples of things that came across my desk at that time. So the first one is on a Sunday morning in Charlotte, North Carolina, Pastor Greg Moss of St. Paul Missionary Baptist Church showed his unequivocal support for Democratic candidate Barack Obama. During an October 28th sermon, he was talking about the importance of voting. And at the end of that sermon, he revealed a t-shirt below his robe. So he opened up his robe and the t-shirt said OMG, which I asked my 14-year-old son what he thought that meant last night. And he said, oh my God. But no, OMG. And on the bottom, it said, Obama's my guy. Unequivocal support for then candidate Barack Obama. And earlier that month, just down the coast, parishioners attending the morning mass at St. Catherine of Siena Church in Orange Park, Florida, they were admonished by their assistant pastor, Dan Nelson, to, quote, vote for anybody, even a dog, but don't vote for Obama. There were some reports after that was leaked out into the news that he didn't say even a dog. Only a couple people heard that. Other people said he just said, don't vote for Obama. But regardless, his message was clear. It was an appeal to reject Barack Obama, the Democratic presidential nominee at the time. So these are just two examples that came across my desk back then. There have been countless more since then. And it turns out this wasn't an accident. Many of the complaints that we received were part of a coordinated attempt to entice the Internal Revenue Service to strip nonprofits of their tax-exempt status so that they could set up this legal challenge. And as an organization, an organization known as the Alliance Defending Freedom, a Christian legal group, launched Pulpit Freedom Sunday in 2008. And this is an event during which participating pastors across the United States deliberately use the pulpit to endorse or oppose candidates during Sunday sermons in October, just weeks and sometimes even days before Election Day. The participating pastors were then urged to send their sermons to the IRS. ADF announced this campaign in a press release on its website in September of 2008, and they explained that, quote, pastors will exercise their First Amendment right to preach on the moral qualifications of candidates seeking public office, despite federal tax regulations that prohibit intervening and participating in political campaigns. So this was very purposeful. Since the passage of the Johnson Amendment, it has faced legal challenges and political efforts to weaken or repeal it. They've primarily come from a subset of religious organizations and political leaders who claim that the law infringes upon free speech and religious freedom, but the courts have consistently upheld its constitutionality, and any attempts to weaken or repeal it have failed. In fact, in 1992, my organization, Americans United, filed a complaint with the IRS after another church at Pierce Creek in New York published ads in newspapers like the Washington Times and the USA Today, encouraging Christians to vote against Democratic candidate Bill Clinton. 3 years later, the IRS revoked the tax-exempt status of the church. It was reported that that was the first revocation of its kind. And the church sued, arguing that the Johnson Amendment violated the First Amendment rights. But the church lost. This case is known as Branch Ministries versus Rosati. And in that case, the U.S. Court of Appeals for the D.C. Circuit upheld the IRS's decision, ruling that tax exemptions are a form of a government subsidy and that conditions on those subsidies, such as avoiding partisan endorsements, do not violate free speech or the religion clauses or the Religious Freedom Restoration Act. The court affirmed that churches remain free to speak on political issues, but cannot engage in partisan campaign activity while benefiting from tax exemption. As we heard and know, in 2016, President Trump vowed to, quote, get rid of and totally destroy the Johnson Amendment in a ploy to pander to the evangelical vote. So it was unsurprising that during his first administration, he issued an executive order directing the IRS to exercise leniency in enforcing the amendment among religious groups. But the Johnson Amendment is a statute. The executive branch cannot repeal or nullify it by order alone. So enforcement remains at the discretion of the IRS. And as we heard, the executive order really did nothing to change the law or repeal it. So that brings us to our current challenge to the Johnson Amendment, the National Religious Broadcasters versus Long case. In August of 2024, the National Religious Broadcasters and two Texas churches, Sand Springs Church and First Baptist Church in Wascom, filed a lawsuit against the IRS in Texas, alleging that the Johnson Amendment, again, violates their First Amendment rights to freedom of speech and free exercise of religion. It also included claims that the Johnson Amendment violates their Fifth Amendment rights to due process of law and equal protection and the Religious Freedom Restoration Act. The plaintiffs in these cases contend that the churches and religious nonprofits have been chilled by the law's threat of losing tax-exempt status if they speak out against political candidates, particularly from the pulpit. They argue that the enforcement has been arbitrary and discriminatory and treats some organizations differently than others. So initially, the government defended against the suit. In December of 2024, the defendants filed a motion to dismiss, arguing that the court lacked jurisdiction and the plaintiffs failed to state a claim. That motion was dismissed as moot a couple months later, and the Trump administration then flip-flopped and ceased defending the law. And the consent decree was proposed back in July. We have filed a motion to intervene since the government has decided to not defend the law. And we are scheduled to have a hearing on that motion to intervene on November 25th. So what happens in that case remains to be seen. I know I'm out of time, so I will stop there. Thank you.
But you set the stage perfectly, Rebecca, for our next speaker, Kevin Hancock, who is not an intervener. He is an amicus, and so can speak a little more about what his organization has been arguing about this issue. Kevin.
Good morning, and first, thank you, Christy, and thank you to Canopy Forum for having me. It's a pleasure to be here. My name is Kevin. I'm a director of campaign finance litigation at Campaign Legal Center. CLC, we are a nonpartisan legal organization that's dedicated to solving the wide range of challenges facing American democracy. And I want to talk a little bit today about why the proposed consent decree that Rebecca was discussing in this case, in our view, poses a serious threat to the Johnson Amendment and to democratic transparency. So on the surface, the issue in this case can seem quite narrow, right? The issue on a surface level is whether two particular churches who are organized as C3s can endorse or oppose political candidates. But in our view, if the proposed consent decree is approved, the result could really fundamentally alter how campaign money flows through the nonprofit and religious sectors in the United States. In short, we believe it would lead to the creation of what we've called religious super dark money groups. And that is houses of worship that can engage in taxpayer-subsidized anonymous election spending. That would make what is already a bad, dark money problem in this country far worse, further eroding voters' rights to know who is trying to spend money in order to influence their votes at election time. And so for this reason, CLC teamed up with two other organizations, Common Cause and Public Citizen, to submit a friend of the court brief in this case to urge the court to reject this consent decree. So the Johnson Amendment, as you know, my colleagues on the panel have already very well described, enacted in 1954. Since then, it has drawn a clear, bright line rule that charitable and religious C3s cannot participate or intervene in political campaigns. The purpose of that amendment is straightforward. It's to preserve the integrity of the charitable tax exemption by ensuring that taxpayer-subsidized donations are not used for partisan electioneering. The rule doesn't silence churches or charities on questions of morality or public policy. They remain free to teach, preach, and advocate on issues, but what they cannot do is transform their tax-advantaged status into a vehicle for electing or defeating candidates. Having this bright line rule for the last 70 years has really mattered. You know, as my colleagues have discussed, there have been churches that have tried to push the limits and have brazenly broken the rule. But by and large, there has been a lot of observation and respect for the rule, even though the IRS doesn't exactly have a stellar record of policing the nonprofit world. And so with this case, we're very concerned about this consent decree and this lawsuit because we believe it poses a grave threat to the Johnson Amendment. The plaintiffs, which include two churches that are C3s, filed this suit claiming that the Johnson Amendment violates their speech rights and free exercise rights. The parties, again, the plaintiffs and the IRS, have jointly proposed this consent decree that would allow the two churches to endorse or oppose political candidates, and this is the exact language used in the decree, to their congregations in connection with religious services through customary channels of communication about matters of faith. Now that language matters a lot because that's what would appear in any court order. And again, at first blush, this may seem narrow, just two churches. The plaintiffs even say, look, this is just two churches trying to have a family discussion concerning candidates with their congregations, no big deal. But in reality, the consent decree's reach would be far broader than that, at least in two critical respects. First, as a practical matter, this consent decree, if it were ordered by the court, would apply far beyond these two churches. If ordered by a court, the IRS would be exceedingly unlikely to enforce the Johnson Amendment against other houses of worship, given the court order. And in our view, the result would be a de facto repeal of the amendment, not achieved by Congress, but by the IRS. Second, the substantive reach of this decree would stretch far beyond anything resembling a mere family discussion about candidates. The plaintiff churches in this case themselves admit that they regularly broadcast their sermons online, and that if the decree were approved, they would use those platforms to host appearances by favored candidates, compare the positions of various candidates, and urge parishioners to vote in certain ways that align with the organization's teachings. Other churches could easily follow suit and more aggressively interpret this court order's language. For instance, a C3, a church, could easily argue that its customary channels of communication with its congregation include radio, newspaper, television, internet communications, all of the customary channels that groups today use to advocate for the election or defeat of candidates. It's the very type of public communications that the Supreme Court has said have a dramatic effect on federal elections. And so once religious C3s are permitted to spend on broadcast and digital political advertising, you've now laid the groundwork for the creation of a new category of political actor. Again, what we call religious super dark money groups. Now, what is dark money? Dark money means election spending where donors are hidden. Voters have a right to know who's spending to influence their votes so they can make informed choices at the ballot box. Transparency really is the foundation of informed democratic decision-making. It's also very important to the prevention of corruption. When donors are not publicly disclosed, it makes it easier to get away with bribery. It makes it easier for prohibited donors, such as foreign nationals, to inject money into our elections and campaign finance system. We already have a significant dark money problem in this country. Nonprofits organized under 501c4, social welfare groups, have already become major conduits for dark money. Like C3s, C4s are not required to publicly disclose their donors, but unlike C3s, the IRS has allowed C4s to spend money on partisan campaign intervention so long as doing so was not their quote unquote primary purpose. So in practice, C4s can spend up to 49% of their expenditures on electioneering without threatening their nonprofit status. That system has led to billions of dollars in undisclosed election spending in our country. For the 2024 elections alone, nearly $2 billion was spent in dark money. And again, that means voters did not know where the money was coming from. Now, if that system is applied to religious C3s, there are three reasons why the situation would get so much worse. First, churches are even less transparent than other C3s and C4s. They don't file Form 990s with the IRS. They don't even have to apply for tax-exempt status. And the IRS has special rules where audits of houses of worship are sharply limited. Perhaps most importantly, second, unlike C4s, C3s can offer donors both secrecy and a charitable tax deduction. This powerful benefit is something that no other political vehicle can offer. This would create a massive incentive for the wealthy political donors to reroute their election spending from C4 dark money groups to religious C3s. Finally, if religious C3s were allowed to spend on electioneering, they potentially could spend 100% of their money on that activity. This court order, if approved, suggests that the type of electioneering described in it doesn't even count as campaign intervention under federal law. And so there would theoretically be no limit on what these groups could spend on elections. The amount of money we're talking about is enormous. There are more than 300,000 religious C3s in this country. If even a small percentage of those shift their spending towards partisan activity, it could unleash hundreds of millions of more dollars in dark money into our campaign finance system. Another major problem is that once that door is open, the pressure that political donors would likely put on houses of worship and other religious C3s would be intense. If wealthy donors who desire anonymity learned that their contributions could earn a charitable tax deduction while supporting their favored candidates, many of them would redirect their giving accordingly. Religious leaders could face expectations or demands to take partisan positions, and then congregations could divide along partisan political lines once particular churches took positions on particular candidates. In short, we fear that this consent decree could blow a wide hole, a loophole in the campaign finance system that we're greatly concerned about. I'm getting towards the end of my time. I'll just add that in our view also, there is nothing unconstitutional about the Johnson Amendment, as has been suggested in this case. It doesn't prohibit speech. It just says that you can't use a taxpayer subsidy to finance election-related speech. And I will leave it at that. Thank you so much.
Thank you so much. Such an important dimension of this discussion. And now we move to Mark Valeri, who I discovered late in searching for speakers and was delighted when I found him. He did apologize to say that he is not a lawyer. He said, no apology needed. We need a historian to keep us in check. So Mark will, I suspect, provide that check and give us a historical background, not only on this issue, but on broader themes of religion and politics and how houses of worship should engage. Mark.
Thank you. It's a privilege to join this conversation. I'm a historian of American religion, not a legal scholar, but I think the Johnson Amendment raises issues, especially for churches, synagogues, mosques, and temples that have historical dimension. And that dimension is, it's a clarifying issue on the proper bounds within a community of worship between a sanguine, wholesome political, moral advocacy and an unwholesome, problematic partisan advocacy. I mean, the Johnson Amendment was passed in 1954 because Lyndon Johnson was being slandered by right-wing nonprofit organizations. So it had a very narrow political intent at the beginning, but it also took place at a time in which there was a huge religious presence in American politics. Reinhold Niebuhr, on the cover of Time magazine, the favorite theologian for Jimmy Carter and Barack Obama, later period. But Niebuhr was a public figure who spoke about politics, who talked about American foreign policy, especially. J. Fulton Sheen, Roman Catholic bishop, was one of the first people to have a widespread television show at this period in which moral issues blended into some sort of indirect political advocacy. And more important, the United States Conference on Catholic Bishops during the 1950s began to issue one decree after another that talked about political issues. What the law did is help, in essence, these religious type draw a line between that religious speech and partisan advocacy, voting advocacy, not only from the pulpit, that is naming names from the pulpit or parties from the pulpit, but also fundraising for candidates, exercising spiritual disciplines on parishioners who voted a different way. This recently came up in the Jewish synagogue in New York City, which forbade any of its members from attending the October high holidays if they didn't register to vote. And the implication was strong that their vote was to be against Mamdani in the political election. But what's interesting to me is how the Johnson Amendment's line that it drew really fit what had been common, mainline, especially Christian practice in the period. Remember that in the Protestant and Catholic tradition, one does not preach on issues from the pulpit. One technically never preaches on issues from the pulpit. One always preaches on a text. The text, scripture or church tradition as it interprets scripture, is the guardrails, is the bounds, is the authority. So the notion that one didn't leap to political advocacy actually fit with the common seminary, pastoral, rabbinic teaching. One was always accountable to the text, the scriptural text. And the text does not mention the names of political candidates or contemporary political parties. So one could use the text to speak on moral political themes, justice for the poor, equitable courts, the dangers of racism against violence, the way to conduct war. The U.S., to return to the U.S. Conference on Catholic Bishops, the dominant language in this period was about human rights. At every turn, human rights became its major focus, and human rights meaning both globally, in terms of the decolonization movements and poor relief overseas, work with famine and disaster relief, also racial problems and poverty problems in the United States. So there has always been political advocacy from the pulpit in that sense, to the extent to which, from the Protestant and Catholic prescription, scripture and tradition validates it. The movement into explicit advocacy of a contemporary person or political party was always given the label idolatry. It moved into the realm of idolatry, and this is very Niebuhr-esque language at this point. So that line tended to be observed in practice for the most part in Protestant churches through the 60s and the 70s, even the 80s. It begins to shift in the 90s with the moral majority on the religious right, but especially took a huge shift during COVID. That is when, because federal laws decreeing you couldn't meet in churches because of COVID without a lot of strict regulations, really was the first outburst of explicit political speech from the pulpit in the contemporary era. It was a resistance to COVID regulations, and that really pushed things to the fore. I think that the problem with advocating ways to vote and partisan politics then is bounded by the scriptural guardrails of the Christian and Islamic and Jewish traditions. So it's interesting that the challenge to that comes from Christian groups, charismatic and extremely conservative Catholics who think about contemporary revelation, who have visions and prophecies that go beyond the boundaries of Scripture, and therefore give them spiritual license to teach about such things. So if we were to go behind some of the advocates for explicit political speech, they would use language about contemporary revelation rather than scriptural revelation as being the mandate for that. The danger is obviously factionalism in the churches. There's a pastor from Tennessee named Greg Locke, who's the pastor of the Global Vision Bible Church, who during the COVID period was very explicitly, strongly political and Republican-y, right-wingy. But his story is that over the last 3 years, he's backed off of that and realized that it was dividing his church so much and creating such sectarian division within the church that he's backed off of that. As an interesting case study. But the final thing I want to end with is the most important, I think, is a theological point, which is from the Christian theological position, having a sermon or a disciplinary action which ends in a partisan position is to say that that partisan position is the end of the message, is the goal of the message, is the real purpose of the message, which is to rob the theological voice of its transcendent prophetic purpose to rise above the situation and speak about larger universal issues throughout. So I know I'm out of time. I'll stop there.
Wonderful. I am just typing a note to our audience to remember that they can insert their questions into the question and answer box, and we do hope to get to some of those. But I just want to say this is has been an incredibly rich discussion so far. Several of you have brought out elements to do with the Johnson Amendment that I didn't bring out in my short introduction, but I want to lift up some of those. Thanks to Professor Valeri for mentioning that kind of beginning with Lyndon Baines Johnson and how the Johnson Amendment did not have the most apolitical, more kind of inception. He was concerned about his own political prospects. And thanks to Rebecca Markert for mentioning that important Pulpit Sundays initiative from 2008 to 2017. That was an important moment in this discussion of Johnson Amendment and political endorsement. Another thing that I forgot to mention in the introduction was that there have been two surveys, important surveys by Public Religion Research Institute, PRRI, one in 2017 when this issue came about in the first Trump administration, and then more recently, I think in 2023 or 2024. And basically, religious clergy do not want this. There is a sense that this is not popular, except for that particular subset of Christian groups that Professor Valeri has mentioned. So I wonder if we can say something about that at some point. But I did want to actually pose a question to Ben Leff, because I noticed that in the New York Times op-ed that he posted, the New York Times editors quickly pulled out the title. They gave it the title, "The IRS is Trying to Uphold a Core Liberal Principle," drawing from a paragraph where Professor Leff is saying, but the core of the IRS's proposal is correct. You don't need to be a conservative evangelical to think so. It's a central liberal principle that the government should not restrict political speech. The IRS can and should revise the Johnson Amendment to protect the speech rights of charities without creating a campaign finance loophole. Benjamin, I wondered if you could tell us something about this idea that the Johnson Amendment protects a liberal principle, and I think you also proposed that that there would be ways for houses of worship to keep these endorsements in the house, and that they might not escape through some of those customary means of communication that Kevin Hancock mentioned. But could you give us a little sense of the argument about the liberal principle behind the Johnson Amendment?
Sure, absolutely. Thank you so much for pulling that out. And obviously, when we use the term liberal, we're always at risk because liberal means two things. One is the whole Democratic Party and everyone kind of to the left of the center, and the other thing has to do with a set of principles that of which free speech and other constitutional protections on diversity are at the very heart of it. So let me just start by saying, responding to your first question, which is like, of course, all of us agree that churches should not be endorsing candidates. And of course, in our religious traditions, I'm Jewish, I don't want my pastors to be, my rabbis in this case, to be endorsing candidates. The vast majority of religious leaders do not want that, and that's because they correctly recognize all of the parade of horribles that Mr. Hancock described, all of which are true. That's all true. The First Amendment is not for them. The First Amendment is not for the pastors the First Amendment is for idolaters. Like the First Amendment is for the people on the fringe. That's why we have a First Amendment. And that's what I mean when I say liberal. Like liberal to me means we construct a society that protects the minority voices in it. And we take that very, very seriously. So that's the foreground. The more subtle or more important issue is, again, I just want to endorse everything that Mr. Hancock said, especially about how dangerous dark money is in our campaign system right now. Forget about C3 organizations involved in politics, and how I love the phrase that he's created for this, these super dark money churches or super dark money. True. I think that that's the risk. So when I talk about how do we not, I've been calling it sliding down the slippery slope of subvention because I'm like really perversely attached to alliteration. But how can we create a thing that vindicates First Amendment rights without sliding down the slippery slope of subvention. And there's a very compelling argument that that's kind of impossible, that we're going to slide down it somewhat, or certainly the only way to prevent sliding down it would be some very narrowly crafted language and an IRS intent on enforcing that narrowly crafted language. And we may just not live in that world. So it may be that from a really, really true point of view, this is not going to be good for our country to open the door that I am arguing that we need to open because the Constitution requires it. So, but let me say one last thing, which is in the way of disagreeing with the two co-panelists who talked about the law. The constitutional issue is actually quite narrow. I think that the way that Ms. Markert described it is accurate, but feels very misleading to a lot of people. It is not true that the government can offer tax exemption to charities on condition that they not engage in campaign speech. They cannot require them to give up their core First Amendment values rights in order to receive a tax deduction. And that's not what branch ministry says. Branch ministry says they can do it so long as there is an alternate means for them to engage in that speech. And the branch ministry's case was not about pulpit speech. It was about a full-page ad that ran in a major national newspaper that they paid for with cash, and to add insult to injury, after saying you got to vote against Bill Clinton, at the bottom it said tax deductible contributions gladly accepted for this project, or I don't remember if that's the exact language. So it wasn't about pulpit speech. It was obviously the most egregious example of a violation of the Johnson Amendment. The church was explicitly using tax deductible contributions in order to pay a media outlet to communicate a purely political it wasn't purely political. It also said that abortion was bad along the way, but a purely political message. So the fact that the court said that's obviously constitutional for the government to employ this non-subvention doctrine to prevent charities from doing that does not answer the question, well, what is the mechanism, or how can they employ the mechanism? Which in branch ministries, the court, which was DC Circuit Court, said the IRS is permitting them this affiliate structure, and they can communicate through the affiliate structure. They can create a C4 that will create a 527 organization. This is just tax numbers. That organization can endorse candidates. So it implied that that pulpit speech is not protected speech, but that wasn't kind of as part of the question at all. So it's a much more subtle question. And the question, what is the mechanism, and how can that mechanism be as narrow as possible? That's been the focus of my work for the whole time I've been writing. And I have an article called Fixing the Johnson Amendment Without Totally Destroying It. The whole point of that is to talk about what are the mechanisms that we could use to keep this exception that permits charities to endorse candidates, which I think is protected by the Constitution, to keep that as narrow as possible and prevent all of the horrible outcomes that Mr. Hancock is accurately describing what's going to happen.
So I want to give Kevin and Rebecca.
So why is it a liberal principle? It's a liberal principle
Yeah.
because the First Amendment is a liberal principle.
Right,
And the
right.
First Amendment, taking the First
Right.
Amendment seriously, means that houses of worship that choose to engage in core political speech, that's their right. That's what the First Amendment
Right.
says.
So I want to give Kevin and Rebecca an opportunity to respond and keeping it as accessible as possible, even for the non-lawyers. But I did want to lift out something, and it did occur to me, Ben, as you were talking, that there is this idea of, well, the free speech value that the churches are asserting, but then there's the question of who pays for that speech, the slippery slope of subvention, and do we as a public want to subsidize that speech? So those may be two important questions to separate. But Kevin and Rebecca, would you like to respond?
Sure. Yeah, I'm happy to go. I guess so. Two like high level general responses. I think Professor Leff hit the nail on the head when he says that we just don't live in a world where we won't face the slippery slope problem, right? In the world where the IRS is never going to robustly enforce the Johnson Amendment or any of these rules in the nonprofit sector, and in a world where campaign finance operatives are going to take advantage of any exception that would be permitted in the Johnson Amendment you're going to end up with the parade of horribles, I think, that I described. I mean, the bright line rule has a lot of enforcement value given the reality of a weak IRS in terms of enforcement. Any fuzzy exception that needs to be litigated after the fact to determine whether there's a violation is going to invite bad actors to push the envelope to see what they can get away with. The history of campaign finance is just that, just bad actors trying to get away with what they can. The Supreme Court has allowed that to go on for now a decade and a half, and that's just kind of like the reality I think we face. I guess the second point I would make is I think, even if one were to accept that the Johnson Amendment places some quantum of burden on the free speech rights of churches, and I'm certainly not conceding that, but even if one were to accept that, courts, when there are compelling policy interests that justify such burdens, courts uphold laws and rule that they're not unconstitutional. And, I think that situation would also exist here. The risks to democracy of any exception outweigh any possible rewards, I think, that would be achieved in such granting an exception to the Johnson Amendment of any degree, given the billions of dark money that's been spent and that harms voters. And given that churches, religious C3s have alternatives for this type of speech if they want, right? Like they can create C4s, although we certainly don't endorse further dark money C4 spending or 527s, or, there are other alternatives out there for that type of speech.
Let's give Rebecca the opportunity to respond, and then I see that Michael Broyd would like to ask a question, and we have a very interesting question in the Q&A section about comparative treatments of this in other countries. But Rebecca, any response on this?
Sure. I don't know if I have much more to add than what Kevin had already added. And yes, there was a lot more to branch ministries than I was able to give in my remarks. It was just trying to keep that all accessible and not get too deep into the weeds, and had a lot of other things that I wanted to discuss. But I do think that honing in on this alternative means of speech is important, because we all understand that our rights are not unlimited, and that they can be restricted in certain ways. There's that old adage, the right to swing your fist ends at the tip of my nose. And so these alternative ways, whether it be talking in your personal capacity, or looking at other means of forming a tax exempt organization like a C4 organization, those exist, and I think those are important ways to, as Professor Leff mentioned, uphold the Johnson Amendment without completely destroying it.
Wonderful. Michael Broyd, you have a question for the group.
I do. Put aside the tax issues for a minute. Let's move to the model in which no deductions, nothing is ever deductible of any type. Rebecca, do you favor churches making endorsements? And Kevin, what do you think? Let's put aside the Johnson Amendment and let's recognize that no contributions of any type are ever tax deductible. Do you think ministers should be prohibited from making endorsements of candidates? Then, is this just a tax issue to you, Rebecca? Or do you have a hidden agenda here?
I think if they are not going to take the benefits of tax exemption, then yes, they should be able to freely endorse candidates. But I will say that I do share concerns about our campaign finance system, and I want to make sure that there is accountability for the contributions that they're receiving, or not accountability, but transparency about the contributions that they are receiving. I think the dark money issue is a very real one.
But that's not an issue that relates at all to religions. Dark money abounds in our system, and discriminating against dark religious money when you allow every other form of dark money is itself a problem. Do you agree, Rebecca?
That dark money is a problem?
And that discriminating against religious dark money when you allow every other form of dark money is itself a bad thing.
I mean, I think dark money is a problem overall. And I think that the discrimination in the way that the parties in the National Religious Broadcasters case want to do it is also discriminatory against all other non-profit organizations as well. Whatever approach we decide to have, it should be an even-keeled one.
I agree. What
So
do you
I,
think?
did you
Put
want to
us-
ask Benjamin? Yeah.
Kevin, put aside the tax
Okay.
issue for a minute.
Are you talking about the exemption writ large and not just the deductibility that C3s enjoy?
Yes.
I think there's still a donor disclosure issue. I mean, I would want, our primary concern is that the donors are not visible. And so once you open the door to churches practicing politics, again, the campaign finance money is going to be drawn to that like a magnet, and you're going to have entities. It won't look like things look now, right? Like I accept that there are bona fide there are bona fide concerns on the part of churches currently where they really just want to like engage in endorsements. But what will happen is if you change the laws to allow that, you'll have bad actors come in and transform the landscape, and suddenly you'll have groups that look far different from that, who are attracting money in, doing more than just endorsing from the pulpit. And then, the fact that there's no donor disclosure on the part of these groups is really the thing that makes it so attractive. What we've seen with C4s is wealthy donors who don't want to be disclosed, they're going to find a way to give their money while being anonymous. And I think you just opened the door for these C3s to become just that if you allow that.
Let's let Ben Leff answer that, and then I'd like to ask a question that will bring in something that Mark Valeri said, and then we have a question in the chat about comparative perspectives from other countries. But Ben, on the question of, is
Well,
this just a tax issue?
I was going to say, of course, everything's just a tax issue. If it's not a tax issue, then don't listen to me. But because I'm on this panel, I will say something really brief, which is just that if there was no tax hook here, in other words, if there was no government subsidy being provided, I don't think there's any way in the world that a discriminatory legislation against organizations because they are houses of worship and what they can, what speech they can engage in could pass muster. Now, if you expanded it to all charities, you took away the tax deduction from all charities and you said anything that holds itself out to the public as a charity cannot engage in any kind of campaign speech. There might be an argument there, but it would be a very hard argument to make that you wouldn't have any of the Supreme Court precedents that justify why we can have a restriction on speech in this case. I think it would be absurd with the current Supreme Court, but I think it would be extremely difficult with kind of any Supreme Court that we've had, at least in my memory. But again, if it's not a tax issue, don't listen to me about it.
I'm gonna seize the opportunity as moderator to ask this question, which is inspired by Kevin's mentioning of how much money is involved here, how much money religious donors could funnel through these groups. And also something that Mark Valeri said about how human rights and concern for global issues was such an important part of the history at the time that the amendment was done. We're at a time now, due to government policies, the SNAP benefits, the, closure of USAID, that many charitable organizations are being called upon in new ways to give to replace those funds that are no longer coming from our government. And I just wonder if, the money that would be diverted to those sorts of charitable aims, whether domestic or global hunger, if those would end up being funneled more into this political campaigning. Would there be a sort of diversion of resources that would happen if this is loosened up and donors can give not just to global hunger charities, but now they can give to politicians? Is that something to be concerned about? I mean, I feel like what we do when we carve out what's exempt or not is also a statement of our values and how charitable funds should be directed. Am I off base and wondering if there's going to be a massive shift from funding traditional charitable enterprises to funding political endorsements? Everyone's speechless. No one's
I
worried.
feel like I'm not in the business of predicting the future, but I do certainly think it is very legitimate to imagine what changes to behavior would take place. And even if it was just 4 billionaires giving, you know, a couple of $100 million each, I think that would have an impact. So, but I don't know how you would predict changes to a whole sector based on changes. And I don't know whether the IRS would do anything to try and protect the obvious limits. So like, you know, one of the things that people don't think about a lot is like, tomorrow I could create a house of worship. Like it's extremely easy to do. I just have to get some people to worship together. And sometimes people think about like houses of worship with new or crazy theology or something. But Judaism, you know, no one owns the IP on Judaism. I could just create a Jewish congregation tomorrow. And if I can get like 6 or 7, ideally 10 people to come together and worship with me, then we have a house of worship. And if I want to spend a couple $1 million communicating to each of them about candidates for public office, as Mr. Hancock pointed out, like that's not going to be, I don't have to show that I'm spending money on anything else. I can embed all of those communications in my worship service. The question of the, you know, are there any boundaries to this has to do with what if I want to communicate to someone other than those 8 people who are willing to show up at my house to daven together? And that is like that's where the words and enforcement could protect. Under the current wording, it's extremely susceptible to abuse. In other words, just lodging these few lines in a consent order and then the IRS walking away from it is a terrible way to invite the changes to law that are going to take place. I don't know how to predict how dramatic they would be, but I think it's bad enough just to know that they potentially could be very dramatic.
So I'll keep my question out there about diversion of resources, but we do have this question in the chat about whether other countries do it differently or there are exemptions for pulpit speech in other countries. Has anyone done any comparative study of this?
I don't know of any comparative study, but I will say something very briefly just about comparative studies in the world of tax and charity in general. One of the things that makes that very difficult to do is that the US structure where you get a deduction from your income tax to make charitable contributions is extremely rare globally. Most countries don't have a crazy income tax like ours, which is full of all of these weird deductions. And very few of them rely on deductions for charitable organizations. So I haven't done any comparative study, but I wouldn't be surprised if this kind of particular issue doesn't quite come up. Also, of course, many countries around the world don't have the prohibition on established churches that we have. And so the very strong constitutional protections for the idolaters don't exist in lots of countries around the world. And so it might not be a problem for that sense as well.
So I'd like to invite Mark Valerian because I see him nodding. Yeah, what would you like to say to us here?
Yeah, I don't know the question about the diversion of money. I think that's an interesting one. I do know that I taught for a semester in Northern Ireland, and my one comparative experience is there is no external prohibition or certainly no internal prohibition against explicit politicking, raising money for particular political candidates. Whether it was a church on the border with the Republic of Ireland that was raising money for the IRA, or a church in Belfast that was raising money for the UDR, the Ulster Defense Regiment. It struck me as an American how politicized that aspect was. So my one comparative is Northern Ireland.
So maybe this is a case of American exceptionalism, this whole conundrum that we're dealing with here. I want to say as we come up on the 5 minutes till close part that I've, well, great and deeply grateful to all of you for joining. This comes on the heels of a wonderful webinar we did last month on immigration, and many, if not most of you, have already submitted essays, which will be published on Canopy Forum in the coming weeks. We may have actually be delaying them until after the Thanksgiving holiday, so we catch people when they're fresh in December, but we're making that determination. So do look for essays at canopyforum.org. In our final 5 minutes, I do want to give you each 30 seconds or so to add anything, any final notes. I saw Ben's hand up first. Ben, would you like to go?
Well, I've been resisting talking about what the law was prior to, or what the current law is, what the IRS's interpretation is. And because I'm a tax lawyer, I spent a lot of time reading the IRS's guidance on this, which is contained in this thing called Revenue Rule 2007-41. And so just there is a belief that there is a bright line. And I think the vast majority of religious organizations abide by that bright line bright enough. And so changing anything is going to disrupt that. But the line is actually not bright at all. The line, there's guidance, and the guidance is kind of technical. And just to illustrate that, I think that Rabbi Broid's idea that when he takes off his prayer shawl and he goes over and waits, goes over to the oneg and waits until he's not officially the rabbi, and he says, hey, I'm not speaking as the rabbi. Under the IRS guidance, that probably doesn't work. In other words, everything you say at that moment probably is still attributed to the organization if the IRS were to try and figure out. And that's because the IRS has explicit guidance about how an individual how an individual charity leader can speak on their own behalf. And they have a bright line. You cannot do it at an official meeting of the organization or in an official publication. And anything you say cannot distance you from representing the organization. So if you're at an official meeting and you say, vote for X, then no matter what you say or what you do symbolically, you're speaking for the organization. The organization has violated the Johnson Amendment. That's the guidance from the IRS that makes it clear that the IRS thinks that pulpit speech is a violation. And then similarly, there's a much more vague part where it talks about using resources. And there's a pretty good argument that if you're standing in your synagogue, a synagogue that was paid for with subsidized funds because you got tax deductible contributions, and you use that space, or if you speak to your members by using your membership list, which also is an extremely valuable asset of 501c3 organizations, including churches, that they pay for using the subsidized speech. If you use your membership list to speak, or the people who are gathered because they're members of your organization, that's a violation of the Johnson Amendment. So there's this kind of idea that there's a bright line. The IRS has kind of done some good work to try and draw a bright line, which they're now deeply undermining, but it's kind of not as bright as we would want it to be. And I think inherently, because of trying to separate out things like individual speech from the corporate speech, or the speech of the C4 affiliate from the speech of the C3, or the speech of all of those things, separating those out are deeply technical tax questions that there has to be a theory of it, and the IRS has to be able to defend that theory, or else we're in a situation where the good actors think there's a bright line and they don't do anything. And arguably, I don't want to call them the bad actors, but the actors with a different theory about the combination between religion or other nonprofit things and political speech just completely flout the law. That doesn't seem like a good situation to me.
We've got 2 minutes. Michael Broid, would you like to close us out? Does anyone else want to get in?
I think that most of this has focused on tax law. And I wish it focused more intensely on both the question of what's in the best interests of religion and what's in the best interests of the public of the United States. The tax law question ultimately is, I'm sorry, Benjamin, a minor issue. And tax law is really for the nerdiest of the law professors. But there's a grand issue as to whether religious participation in the destiny of the United States is a valuable and good one, and how much participation do we want of religious figures in America?
Okay, I'm getting word that we're not a hard stop at 12. We can be a little flexible, but thank you for that, Michael Broid. Rebecca, would you have any concluding remarks?
Yeah, I just want to bring up the surveys that you had mentioned, Christy, also that the public support for the Johnson Amendment is robust and consistent among demographic and religious lines. And one of the surveys that you had mentioned was in 2023 by Public Religion Research Institute, and they found that 75% of Americans opposed allowing churches and houses of worship to endorse political candidates while retaining their tax exempt status compared to just 20% in favor. And this was consistent with previous studies and really just told us what we already know is that congregants prefer their religious institutions to focus on spiritual matters and not partisan electoral politics. It's a very American thing to not be to not want to be told what to do and not to have somebody tell you who to vote for. It's a very sacred right for Americans. And I think that the popularity, the enduring popularity of the Johnson Amendment is something that needs to be highlighted here.
Yep. Kevin, final thoughts?
Sure, thank you. I guess I'll just amplify one concern we have about the case, which has been touched on a little bit, but it's about the way democratic change is made in this country. So I think like reasonable minds can differ over the Johnson Amendment and where exactly the line should be drawn. But at the end of the day, it's a federal law that was enacted by Congress. One thing that's really troubling about this case, I think, is that you have a situation where you have an administration that's on the record as wanting to destroy this federal law. Congress has not been willing to do that over the decades. It apparently is not willing to do that now. Otherwise, one might expect it would. And so, a concern, I think it's right to be concerned about the IRS kind of joining up with a like-minded plaintiff that apparently shares its policy goals in this area, trying to circumvent the power of Congress to change the law by enlisting the help of a court to try to do it instead. If the people of this country support changing the Johnson Amendment, they can talk to their representatives and Congress can make that change if it wants to. In the absence of that, I would hate to see that affected through like the back door by having a court in Texas do it like this.
Thank you. Mark O'Leary, final thoughts?
Two really quick ones. One is we've not had discussion of the African American church in which political figures and political speech is so infused with moral and spiritual direction and urgency that I think that this complicates that. We said there is no bright line. This complicates that line even further and has porous boundaries between the two. So I wanted to bring that in to keep into our consciousness at this point.
Thank you very much. And thanks again to all of you for generously giving your time this Friday morning for this stimulating discussion. Again, the recording itself will be posted on our Canopy Forum website, and we're looking forward to publishing the essays. Happy Thanksgiving in advance to all of you, and thanks much.
Take care. Thank you.